This is Kelly from Watch the Obsession. Thanks for taking time to watch this video. Please click like and subscribe and hit the bell for future notifications.
In the documents obtained by Fox News, the subpoena demands one of the surviving roommates, Bethany Funke, appear in court in June to testify at Bryan Kohberger's preliminary hearing. This is not the roommate who witnessed a masked man in their home the morning 4 of her friends were murdered, but a second roommate who told police she was in the basement at the time and never went upstairs.
After the channel's most recent live stream, I was thinking about this. The amount of information that the defense team, Bryan Kohberger's defense team, led by Ann Taylor, has managed to get out to the public, to the masses, to potential jurors in the midst of a strict and broad gag order that has been in effect since January 5th, 2023. Before we get into the rest of this video, I just want to acknowledge the victims and their families. The victims, Kelly Gonsalves, Madison Mogan, Ethan Chapin, and Xana Granodal. May we find justice for them and peace for the families. And then I was also thinking about this, which is a statement I read a couple times during the live stream that is from the defense's objection to the state's motion for a protective order regarding some of the DNA evidence, and particularly the investigative genealogy DNA evidence. So the statement reads, no matter what came first, the car or genetic genealogy, the investigation has provided precious little. There is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's car, office, apartment, home, or vehicle. So what exactly does that mean? When I first read that statement, or when I was first thinking about that statement, I was wondering, oh my gosh, does that mean that there is literally no evidence from the victims in Kohberger's apartment, office, car, or his space anywhere that they have investigated? But then I thought about the show that the defense has been putting on ever since the pretrial proceedings for this case have started. And that is, of course, as far as we know, because many people close to this case are under that broad and very strict gag order. So let's think about one of the first times that we heard from the defense in a big way and a way that made headlines. And that was the defense's motion to compel Bethany Funke to testify at the pre-trial hearing. So what was the defense's reason for compelling her to testify in that pre-trial hearing? Well, according to what they had to say, it was because Bethany Funke had exculpatory evidence that could, well, by the definition of exculpatory evidence, they're saying that could exonerate Bryan Kohberger. Exculpatory evidence is evidence that shows that somebody is not guilty of the crime for which they are charged. So let's go ahead and take a look at that motion to compel Bethany Funke's testimony at the pre-trial hearing and see exactly what it has to say. So here this says, well, the person who is authoring this document introduces himself as an investigator that was retained by the defense for Bryan Kohberger. And I'm starting here at line 7. It says, Bethany Funke's bedroom was on the first floor. The other surviving roommate's bedroom was on the second floor. Bethany Funke was interviewed by police on several occasions. She disclosed things she heard and things she saw. Bethany Funke was present at the home 8 hours later when police were called, arrived on scene, and discovered the homicides. The statement in the document goes on to say, during the course of my investigation, it became known to me that Bethany Funke has information material to charges against Mr. Kohberger. Portions of information Ms. Funke has is exculpatory to the defendant. Ms. Funke's information is unique to her experience and cannot be provided by another witness. So, in my opinion, much of the statement within this document by the investigator certainly is true. Bethany Funke was interviewed by officials. She heard and saw things. She told them about things that she heard and that she saw. And of course, her experience is unique to herself. So, what exactly could this exculpatory evidence be that the defense is continuing to allude to? Now, understand that the defense is under ethical guidelines that, according to the oath that they've taken to be an officer of the law, to be a member of the American Bar Association, they can't just throw out statements that are baseless, that don't have any foundation in fact or any kind of evidence that they are aware of. So for the defense to say that they believe that a certain witness has exculpatory evidence, it's under the scrutiny of the court eventually, if they choose for it to be under their scrutiny, to test the validity of the statement, at least the knowledge that the defense attorney had in making that statement at that time. So Ann Taylor is well aware that she is representing a defendant in a very high profile case, and she has an exceptional trial record history, which is one reason she is a defense attorney for Bryan Kohberger. So unless she's going to put everything on the line, unless she's going to put this trial on the line and her career as an attorney on the line, we have to believe that Ann Taylor has a good faith reason to assert that she believes Bethany Funke might have, or she says has, evidence that may be exculpatory to Bryan Kohberger's guilt. So I'm not an attorney, but our YouTube friend, the lawyer you know, is. So hey, if you haven't subscribed to his channel, it's a great channel with analysis of all of the true crime cases you follow, so definitely check it out. But here is what Peter Tragos, the lawyer you know, has to say about what I was just commenting on.
One of the things about being a lawyer and litigating cases is you have to know how to use leverage and use the tools in your toolbox. And when you feel like you have something, you have to use it appropriately and ethically in order to get what you want or need in a case.
So where does that leave us as far as what the defense has been doing with the amount of information that they have gotten out to the public and therefore potential jurors in the midst of a strict and broad gag order, starting with claiming that Bethany Funke has exculpatory evidence proving that Bryan Kohberger may not be guilty after all. And then extending into all of the evidence that the defense has requested through 4 different motions and supplemental motions and amended motions from the state, that so far, I guess we know that the state has not given them everything that they want, because they wouldn't continue to make these motions if they had everything that they had asked for. At some point, it would become redundant. It would become pointless. The court would be like, no, this isn't legitimate, and there would be an end put to it, because these are professionals at work that we are observing. Based on what we understand about the ethical and moral obligations of attorneys, it's not like Ann Taylor just made a wish list of everything she wished that she could have her hands on as far as evidence to prove her client's innocent, because that would be unethical. So all of these things that Ann Taylor has alluded to, or that she has requested from the state through motions, she must be doing so on a good faith basis. So in my opinion, where the waters start to get murky is like right here, because the state also has an ethical obligation, and they also just have an obligation by the letter of the law to do things in a certain way in pretrial proceedings. For example, when they present evidence to a grand jury, asking the grand jury to indict the suspect, in this case, obviously, that's Bryan Kohberger, The state or the prosecution also has an obligation to present any exculpatory evidence that they might have or they might be aware of. So this term, exculpatory evidence, is such a big term when it comes to a trial. It's an even bigger term when it comes to a trial of this magnitude, yet we are not clear about the status of any possible exculpatory evidence that might be out there, because we understand that Ann Taylor must be asserting that there is exculpatory evidence on a good faith basis, meaning she must have some indication that exculpatory evidence exists if she is in fact asking for it. Yet the prosecution also has an obligation to present any exculpatory evidence to a grand jury during their proceedings while they are convened. And as we know, that grand jury was convened and they indicted Bryan Kohberger. So based on legal ethical standards, that would mean the prosecution would have had to present any exculpatory evidence during the grand jury proceedings. If they provided exculpatory evidence to the grand jury, one could logically assume that a grand jury by supermajority would not then indict Bryan Kohberger, because they would have seen the exculpatory evidence that showed Bryan Kohberger's innocence or lack of guilt. And well, that's not what happened, because they indicted the man. Yet still, after that grand jury was convened and they indicted Bryan Kohberger, the defense is still asserting that the state has their hands on exculpatory evidence. So where does that leave us with this curious statement in the defense's objection to the state's motion for an order of protection regarding certain DNA evidence that says, no matter what came first, the car or genetic genealogy, the investigation has provided precious little. There is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. It is my opinion that with this statement in this document that was authored by defense attorney Ann Taylor, the statement, there is no connection between Mr. Kohberger and the victims, I feel that she truly must believe to some degree that that statement is true at the time of authoring this document, because this is a really big statement to back up on later down the road. So what I mean by that is, in saying there is no connection between Mr. Kohberger and the victims, if later on down the road in the trial, let's say, Ann Taylor wants to try to justify the fact that Bryan Kohberger's touch DNA was on that knife sheath that was in 1122 King Road, partially underneath Maddie Mogen, God rest her soul, and her comforter, that would be a really hard thing to do after making such a firm statement in this very important and critical document that everybody who is following this case has their eyes on right now. And the question I still have about this statement, there is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. Is Ann Taylor saying, you know, in the lack of discovery that I've received, that I have requested from the state, I currently see no explanation of the lack of DNA evidence from the victims in Kohberger's apartment, office, home, or vehicle? Or does she have actual knowledge? Has she received the evidence through discovery that she requested that would in fact show if there was DNA evidence from the victims in Kohberger's office, apartment, home, or vehicle? Is she making that statement almost sarcastically, as far as you can be sarcastic in a legal document, just saying, hey, because I haven't received that evidence that I have requested yet? Or has she received that evidence and she knows that there is no connection? I guess this is just one of the many questions that we are likely going to be left with until this trial actually goes down. And I think we all know it's going to be a lot further down the road than October 2nd, 2023. May we find justice for the victims and peace for their families. Thank you guys for watching. Please click like and subscribe and hit the bell for future notifications.